A 27-year-old man takes magic mushrooms, enters a state of delirium, runs out of the house stark naked at 3:45 in the morning in minus 20-degree weather, breaks into the house of a total stranger who happens to be an elderly woman, beats her with a broomstick, and is acquitted of all charges. I cannot be the only person trying to make sense of this situation. Viva Frei, Montreal litigator turned YouTuber, and this is a story that is making its rounds in Canadian news, although I think it's going to be of interest to everyone. The facts of this story literally are the facts that I cited in the intro of this vlog. You can read the news articles yourself. I sent a link to one of the news articles in the community tab, so check that out, read the article if you haven't seen it. I'm not going to name names in this video. The bottom line, a 27-year-old man who also happened to be the captain of the hockey team at his university took magic mushrooms at a party one night. People noticed his behavior was a little off, which I guess is to be expected when you're taking magic mushrooms. He tried to go to bed twice and it didn't work, and at one point, sometime around 3:45 in the morning, he gets up stark naked and runs out of the house. Apparently, it's something like minus 19 degrees outside. This individual then proceeds to break into the house of a total stranger who happens to be an elderly lady professor. He then proceeds to beat her with a broomstick. She takes refuge in a bathroom, locks the door, and this individual is found naked in somebody else's bathroom in another house and promptly arrested. He is charged with breaking and entering and assault and ultimately found innocent on the basis of automatism resulting from voluntary intoxication. I initially read this article and thought to myself, agree or disagree with the decision, it seems to be in line with the jurisprudence in Canada. More specifically, a 1994 Supreme Court decision in the Crown versus Davio, in which the Supreme Court of Canada, albeit on a divided basis, came to the conclusion that automatism resulting from voluntary intoxication can nonetheless be a defense to certain types of crimes. That was my initial reflex, and although accurate in law, when looking into the subject a little more, I realized that the situation is actually a little bit more complicated. I'm going to try to make sense of this for you in as much as possible, and for those of you who sometimes accuse me of being a milquetoast fence sitter, be forewarned, I am taking a hard position on this subject. In order to have the slightest hope of actually digesting what is going on here, we need to get clear on certain terms. We have to get clear on the distinction between voluntary intoxication and involuntary intoxication. We have to get clear on the distinction between voluntary intoxication and automatism. We have to understand the distinction between crimes of general intent versus crimes of specific intent. It's complicated, but I think I can break it down so that you can come to your own conclusions on the subject. The distinction between voluntary and involuntary intoxication is pretty easy to understand. Voluntary intoxication means that the individual took the mind-altering substances on purpose. Voluntary intoxication is deliberate and it doesn't serve as a defense. Take the most obvious example of drinking and driving. One cannot get deliberately intoxicated and then say, I could not have committed the crime of drinking and driving because I was intoxicated. That is the crime. An interesting caveat is that even within the realm of voluntary intoxication, it is conceivable to fall into the realm of involuntary intoxication. But before we get there, let's just start with the basics of involuntary intoxication. Involuntary intoxication, the most obvious example, having your drink spiked by someone at a bar. Taking what you think to be aspirin, whereas in reality it's actually a Valium. Having high school kids put acid in a teacher's coffee. Those are the most obvious forms of involuntary intoxication, which can in fact serve as defense to certain crimes to the extent that the intent of the individual was in fact compromised by the involuntary intoxication. That said, there are more nuanced or subtle versions of involuntary intoxication that can nonetheless result from having taken the drugs voluntarily. Think allergic reactions or unforeseen or unforeseeable side effects of taking certain drugs. In situations of involuntary intoxication, it serves as a defense to the criminal act when it affects the accused's intent to commit the act. Oh yeah, and one more terminological thing to get clear here. In criminal law, you have what is known as the actus reus and the mens rea. And typically, in order to be found guilty, one has to be found guilty of the actus reus, that is committing the criminal act, and the mens rea, which is the intent to have committed the criminal act. And when we talk about mens rea, it is not the intent to have committed the crime. It is the intent to have committed the act, which is itself criminal. There are certain types of crimes that we refer to as strict liability, meaning it doesn't matter if you had the intent to commit the crime, all that matters is that you committed the act of committing the crime. Drunk driving being the most obvious of them, it didn't matter if you thought you were under the legal limit. If you were over the legal limit, it doesn't matter if you intended to be over the legal limit, you were over the legal limit, that is the act of the crime. So involuntary intoxication, to the extent that it in fact affects the intent to have committed the crime, i.e. the mens rea, will serve as a defense in criminal law. Going back to the example of the kids spiking their teacher's coffee with acid, it would be fundamentally unjust to hold that teacher criminally liable for any crime he might commit while under the influence of LSD, to the extent that he did not consume the LSD voluntarily or even knowingly. The situation is somewhat different when it comes to voluntary intoxication. A lot of people might take issue with the defense that I can't be found guilty of the crime because I didn't have the intent, because I was drunk, because I got myself drunk. Consequences have actions, and one cannot use their own voluntary intoxication as a defense to the crimes they committed while intoxicated. A lot of people would think that, and they would be right, with a big asterisk. In Canada, we had what was known as the Leary Rule, which was to the effect that voluntary intoxication cannot serve as a defense to a general intent crime. The Leary Rule was subsequently found to be unconstitutional by the Supreme Court in 1994, but before we get there, we need to make the distinction between general intent crimes and specific intent crimes. And this is where things get really complicated, because although it is a common law distinction, there is nothing in our criminal code that makes a formal distinction between general intent crimes and specific intent crimes. The courts have subsequently tried to clarify the distinction between crimes of general intent and crimes of specific intent, but I think I can summarize it with the following example. Assault versus murder is the most clear-cut example of the distinction between a crime of general intent, being assault, versus a crime of specific intent, being murder. In order to commit assault under Canadian law, all the accused had to have had the intent to do was applying force against another person without the consent of that person. The accused need only have the general intent of shoving, slapping, pushing, hitting the person, whatever. When it comes to murder, on the other hand, the individual had to have had the specific intent to kill. So one can have the general intent to slap another person without having the specific intent to kill them, hence the distinction between crimes of general intent and crimes of specific intent. The only problem, not all of the examples in the criminal code are so clear-cut. And when it comes to crimes of specific intent, voluntary intoxication can indeed be a defense, or at the very least a mitigating factor resulting in a conviction for the lesser but included crime. An example being someone who is voluntarily intoxicated and gets into a fight and throws a bottle of whiskey at their friend and ends up killing them. Their voluntary intoxication could have easily had an impact on their mens rea to commit the crime, the intent to commit the crime. And while they intended to throw the bottle at their friend, they didn't intend to murder their friend. And so while it may serve as a defense to first-degree murder, they might nonetheless be found guilty of manslaughter. Now when it comes to crimes of general intent, under the Leary Rule, voluntary intoxication was not a defense. Incidentally, if you hear sizzling in the background, that's not because I've made a good point, it's just because we're cooking soup over here. All right, I'm glad we got that cleared up. That being said, in 1994, in a Supreme Court decision of the Crown versus Davio, the Crown came to the conclusion that the Leary Rule was unconstitutional. The court determined that it was unconstitutional in that it substituted the mens rea of committing the crime with the mens rea of voluntary intoxication. So while the individual obviously had the intent to become intoxicated, they did not necessarily have the criminal intent, the requisite mens rea of the actual crime itself. The Supreme Court in Davio concluded that the Leary Rule was unconstitutional with a but. The court concluded that voluntary intoxication could not serve as a defense to a crime of general intent unless it resulted in a form of automatism. And what is automatism? That is when the accused has rendered themselves in a sort of robotic, autonomous state where they no longer even know what they are doing. That decision in a nutshell: a 65-year-old partially paralyzed woman asks her friend's husband to bring over alcohol for her. Her friend's husband is a chronic alcoholic who had apparently spent all day drinking at a bar, brought over a 40-ounce bottle of rum, and the woman had a glass of rum and then passed out. In the middle of the night, the victim gets up to go to the bathroom. The accused is there. He grabs her, puts her in a room, and proceeds to sexually assault her. He's arrested. It's subsequently determined that he drank the rest of the bottle of rum, and he has absolutely no recollection of the entire event. The court, in a split decision, ultimately comes to the conclusion that the rule set out in Leary, that the mens rea of a general intent offense cannot be negated by drunkenness, is unconstitutional. I disagreed with that decision when we first read it in law school, and I still disagree with that decision today, and the legislator disagreed with that decision as well. Almost immediately after that decision was rendered, the legislators, that is, the lawmakers in Canada, immediately enacted a provision which amended the criminal code, section 33.1, to the effect that voluntary intoxication cannot serve as a defense even to a general intent crime when that general intent crime involves violence. Now, the interesting thing about section 33.1 of the criminal code is that the constitutionality of that provision has yet to be adjudicated upon by the courts, but I think that day is coming. It's coming, and I think it's coming in this particular case. This man, who was 27 years old at the time of the crime, took magic mushrooms on purpose. The foreseeable, if not outright intended, consequences of taking magic mushrooms is for the psychedelic effect, if not to lose touch with reality entirely. How then did this predictable, if not foreseeable, state of delirium serve as a defense to the crime that was accused of him, which was necessarily a violent crime of assault? How did that happen? Well, in a pre-trial ruling in this particular case, a judge ruled that that section of the criminal code was unconstitutional. A pretrial ruling in that case deemed section 33.1, the one prohibiting voluntary intoxication as a defense to violent crimes, unconstitutional. The final ruling then makes total sense in that it is in line with the principles set out in Davio. It's in line with those principles, but not in line with the subsequent amendments to the criminal code because of the shocking outcome in the Davio decision. Now, apparently the prosecutors in this case are in fact contemplating an appeal on multiple bases, one of which is the constitutionality of that section 33.1 of the criminal code. They absolutely have to appeal that ruling, if only so that we can get a decision from the Supreme Court of Canada as to the constitutionality of that provision of the criminal code. And my non-milquetoast, non-fence-sitting opinion is that that provision of the criminal code is perfectly constitutional. And if it is deemed to be unconstitutional for whatever the reason, it is nonetheless a legitimate and justifiable limitation on the rights of individuals. There are always going to be hypothetical examples that can test the limits of any good law. When it comes to voluntary intoxication of substances, the very purpose for which you voluntarily consume them is to affect your state of mind. You cannot rely on your altered state of mind as a defense to violent crimes. Period. We can think of examples that might test the limits of this rule. For example, someone takes Prozac, which is necessarily a mind-altering drug, enters a state of automatism or delirium. Yeah, I can think that that might be an exception to the rule. But when any individual voluntarily consumes mind-altering drugs, they cannot then rely on the fact that their mind was altered as a defense to a violent crime that they committed while in that altered state of mind.
Prove me wrong.
I think the prosecution is going to appeal, and if and when they do, and we have a judgment of the Supreme Court in 5 years, we will see if my prediction turned out to be true. And that is the vlog for today. I hope you liked it, and if you do, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below to feed the algorithm. If you want to support the channel, there are merch links, PayPal, Subscribestar, and Patreon in the pinned comment. Remember, I have a podcast. I am trying to get it on many platforms. It is called Viva Law Podcast. And more important than anything else, just share my content on social media. It helps me grow, and now you know your vlog. Peace out. Booyah!